Nobody is on camera today. Hi, everybody. There's Tom. Hi,
There you
Tom.
go. Got people bopping in.
There we go. What's happening, Joe? Good to see everybody. Nice to see you. We got some good numbers today. Hope everyone liked the topic. Uh, it's finally sunny out there. The rain's finally stopped, which is awesome. It actually looks like spring for a change, which is super cool. Um, Hopefully it's drying out a little bit and you don't have wind damage from these storms that pass through. So we're going to get right to it. I'll have to do my usual announcements. Hey, Jeff, nice to see you. So as everybody knows, these webinars are provided for general informational discussion purposes only. Let's see. Number two, they do not and cannot form an attorney-client relationship. Number three, the information exchanged does not constitute legal advice. Number four, to obtain legal advice, you got to go out and hire an attorney. Us would be great. We vote for us, and but you could also hire somebody else if for some reason you only like coming to our seminars and really don't want to work with us. But nevertheless, to have an attorney-client relationship, you have to go hire an attorney. So, and the last thing, as everyone knows, none of this will be kept confidential. So if you have any secret mulch piles, don't tell us about them because we don't want to know and we won't keep it secret. So what's today's topic? Today's topic today is the board members are lying, stealing scumbags, right? We know that. We know that. Everybody knows that. Everyone has heard that by that guy or that lady who's 3 rows from the back of the open public meeting, or the person who is, for some magical reason, able to unmute themselves on the Zoom call. And you're like, why do they keep unmuting themselves? We can't figure out how can we stop them from breaking into our meeting. So yes, that was tongue in cheek that the board members are lying, cheating, stealing scumbags. We know that the vast majority of board members are kind-hearted masochists who just love pain, right? We know that, right? They just love pain. So they keep volunteering, they keep getting kicked in the teeth, and they keep helping their community in spite of everything, right? Thank God. Thank God. High five to all of you board members out there. We really appreciate all your hard work and the insanity that you deal with at times. So with that being said, though, we got to jump a little digression to the dog of the day because I forgot about the dog of the day. The dog of the day is Betty. There's Betty. Awesome, Betty. Awesome sweatshirt too. I like a nice wardrobe and a nice grooming job on Betty there. So Betty is owned by Elaine Murray. Elaine Murray is an expert on management issues. So she testifies, writes reports with respect to management and litigation issues involving associations and management across the country. But Betty, I'm sure, helps her very much in preparing those expert reports and testifying and doing depositions and all those stressful things. But thanks so much, Elaine, for sending Betty over to us today. And so the first point I have on the substantive side of things is even though the vast majority of board members and managers, et cetera, are honest, hardworking, community-minded people, even a broken clock is right twice a day, right? We know that for all of us who have had psychologists in our lives. Thank you so much. Because twice a day, the clock is right, believe it or not, even if it's not running. And what I'm trying to say there is that, even though 99% of the time, the wacko who stands in the back of the room and says, the board is stealing, I know that person's driving an Audi, which clearly means they're stealing our reserve funds, not that they have actually signed a lease and are making lease payments, but they say they cleaned out the reserve funds and they're scamming the audit and lying to the auditors, et cetera. Even though that's 99.9% of the time nonsense, you still have to ask the question, hi, Mrs. Jones, or hi, Mr. Jones, you say everyone's stealing, everyone's dishonest, the place is being bankrupted by the board. Please tell us why you think that, because if you have any evidence of that, we have to investigate it. And by the way, as attorneys, we would have to investigate that as well. I don't want to digress too much into that, but we do see cases probably every 3, 4, 5 years where people actually are stealing. So when we get those claims from the back of the room or the back of the Zoom meeting, we do reach out and say, hey, what evidence do you have that based on that? We don't automatically dismiss them. We ask the questions because there have been cases that have been significant where our office has been initially tipped off by someone from the back of the meeting who is screaming and yelling, saying there's something not right there. And we do scratch the surface, and we have found issues in the past. So be careful about, don't be dismissive. Do ask for evidence. And if there is evidence, get other people involved, and find out what the story is. Nature abhors a vacuum. The best defense is a good offense. Tell your story. So nature abhors a vacuum. What that means is if you're not getting your story out there, somebody else's story is. Somebody else's story is. So if you have a person in your community who is saying, the association is being bankrupted by the board. I think the manager is stealing. I think the board members are misappropriating funds. I think they're doing bad stuff. I think, even we'll call it a good case, a better case scenario. Oh, the board does nothing. The board does nothing. That's what story will be on the street. And unless you get your story out there, that will be the only story on the street, right? So what I really, really encourage people to do is President's Corner, right? Do a President's Quarter monthly, or do a Manager's Quarter monthly. These are the awesome things that we've done. We've recovered $30,000 in this crazy collection case that we never thought we would get the money, right? That's awesome that we got that money. Fantastic. The board worked really hard. The board met with the attorneys. The board talked to the attorneys. The board filed the motion, all that great stuff. And we got the money. That's fantastic, right? Tell people the wonderful things you're doing, because negative always sells, right? Everyone likes to look at a train wreck, right? That's the term rubbernecking, right? You're always going to look at a train wreck. You're always going to look at the accident on the New Jersey Turnpike. So people are naturally drawn to the negative, and the hyperbole, right? But you want your message out there on the street. We have wonderful receivables, right? We've controlled them wonderfully. We have a very low bad debt expense. We have implemented resolutions and rules and regulations that make this community great. We've adjusted vendors. We had a problem with the vendor last year, and this is what we did to address that. Because otherwise, if you don't have the story out there, somebody will have their story out there. And especially in the era of Facebook, online bulletin boards, and things like that, they are very easily putting their story out there. They're spewing all types of things that people may be listening to that go unrebutted. Transparency. Transparency breeds credibility, right? If you're transparent, people say, you don't tell us anything. You go, that's really interesting, because we have an online portal that has all of our governing documents, that has copy of all of our resolutions. You are welcome to look at it as a member. You have a password. I don't know why you haven't used that password, because you're at a meeting tonight telling me I don't have access to the amendments, and I don't have access to the master deed and all this other fun stuff. And they are posted on our website and have a portal. What does a portal do? A portal says, we are transparent. Number one, here, look at our business. That's great. And number two, it lessens the burden on your property manager, right? So if you have vast resources of information on your community on the portal, you don't have managers having to run around and copy copies of amendment, copy resolutions, copy all this other stuff, and you're burning management resources that otherwise could be avoided by putting those resources online. Does that make sense, right? And it still amazes me how many associations don't put much online at all, if anything. Now, a lot of, so this makes sense, right? Most associations who do have all that information online do it through a password protected sub-site, right? So it's on the main site, but there's a portal that you have to log in through with a member password, right? So credibility. Why credibility? Why do so many people think, that Lee Harvey Oswald is a conspiracy, right? It wasn't just Lee Harvey Oswald, because you have the government, and it's a very hot topic right now in the media, right? You have the government saying, we can't release all the records. So naturally people go, well, you haven't released the records. Doesn't that mean somebody's hiding something? Of course, right? It's human nature to say, I can't release any information to you. Your mind automatically goes, well, if you can't give me the information and you're saying this is the be all and end all of the answer, you must be hiding something, right? So transparency gives rise to credibility, right? The board says, I have nothing to hide. Here, take a look. Have a copy of the audit. take a look at the contract for landscaping. Open meetings. Please, 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 please have open meetings, regular open meetings where you make your decisions. Number one, it's required by law. Your decisions that are binding must be made in an open meeting that is open to the membership. That doesn't mean the membership votes on it. That doesn't mean any members must attend. They just have to have the ability to attend. Month after month, I speak to boards that don't have open meetings. They just don't have them. They don't have open meetings. They don't have their votes at open meetings. And I constantly try to drive it home. And the big problem there is, number one, they're not doing the right thing. Number two, they're generating claims, right? Possible claims by people suing them and or possible claims to the DCA. You'll be shocked to know this. The DCA does not want to hear endless complaints from your homeowners. They don't. The DCA doesn't. The DCA would like everyone to be compliant, everyone to move on with their lives, everyone to be transparent, everyone to have free and fair elections. That's what the DCA wants. They don't want to hear from Mrs. Jones every 2 weeks saying the board blew off an open meeting again. They don't want to hear about it, right? So open meeting is number one required. Number two, it bolsters your credibility. Number three, it stops the nonsense. Document retention, inspection, production, and destruction. That's a resolution that associations should put in place, right? Document retention. What do we keep? What do we keep? How do we keep it? Is it kept electronically? Is it kept in paper format? Are there original maps and drawings of the association from the community when it was created? What do we keep? What do we dispose of? Do we keep every shred of paper and every post-it? You know, McGovern Legal Services Post-it, little advertisement break here. That we have that has a note on it, right? Every post-it that has a note on it, we should call Sally. No, we don't. We don't keep that stuff, of course, right? But what do we keep? What should we keep? How should we keep it? What about minutes? What about votes? What about ballots, right? So there are lots of things you have to keep according to law for certain periods of time. There are a lot of things you don't, right? So you have to keep that in mind. What do we retain? And that includes things like recordings, audio recordings, video recordings, et cetera, because under various new regulations, if you make audio recordings and you make sound recordings, you generally have to keep them for a certain period of time, right, before they are destroyed. What about inspection, right? The right to inspection. This again goes to your management resources. So the statutes basically say the membership has a right to inspect certain documents, the books and records of the association. There are various interpretations of what constitute the association's books and records. I tend to lean on the side of more is better, right? Even the DCA, in my opinion, is a little bit more restrictive in their interpretation of books and records. But again, I'm not a DCA person and I'm also not a judge. I just lean on the side of transparency because I believe it makes everyone's life easier. But so document retention, then what about inspection? The inspection is, hey, I have a right under the statute to inspect the books and records. I have a right to come in and schedule a time at the management office and come in and sit down and look at them. In my world, from an administrative standpoint and as a lawyer standpoint, I would prefer not to have document inspection. I would rather just produce them to the person, right? That does a couple things. Number one, it does not have to have the personal interaction of someone sitting in the management office flipping through bankers' boxes of records, right? They're just produced to them, right? So there's not the personal interaction because a lot of times the person who is seeking inspection of the books and records is not so happy with the association in that particular moment, right? So they may engage with board members or management representatives who have to supervise the inspection, and they may engage with them in a way that is not productive, right? You see what I'm saying? Not a happy time. Hi, everybody. I hate you. Show me your books and records. That's not great. We don't love that. So in my world, if someone says, hey, Fran, I want to come and inspect the landscaping contract, a lot of associations respond to that saying you have to make an appointment on the third Tuesday of the month when it's a full moon between 2 p.m. and 2:15 p.m. No, no, don't play games. In my opinion, you may have to have some things redacted, but send them a copy of the landscaping agreement. Cut to the chase. Otherwise, all you're doing is frustrating a person. You're frustrating a person who, number one, is entitled to the information, and number two, may be helpful, right? So there are people who are helpful, right? I've had many, many, many cases where a question has come from the membership, and the member has found something that was overlooked, perhaps by management and or the board, and they actually helped. They pointed it out in a good faith way, and they said, "Listen, I'm not trying here to bust chops, but I noticed this, and I think the board maybe should take a look at it." And the board goes, "Hey, thanks so much. That's awesome, and we addressed it, and you really helped us. God bless America." Right? So I don't want this to be negative. Members of the association um, can be extremely helpful if they approach it the right way. Um, what about inspection? We talked about. What about production? We talked about. One of the issues with production is there can, not all the time, but oftentimes be redaction requirements. So many books and records, especially when they come to debtor account histories or debtor information, may have information on them that must not be disclosed. So for example, some documents in homeowners associations have social security numbers on them. Some of them have bank account information on them from direct debit authorizations and things like that. And the last thing you want to do as an association is producing documents that have not been redacted that set up either identity theft issues or, again, God forbid, actual ripping off of somebody's bank account information. You see what I'm saying? So that's the production. The destruction part. Why would we talk about destruction, Fran McGovern? We should keep everything forever. That doesn't make sense, right? That doesn't make sense. I still have associations that have, 200 bankers box somewhere, and they're storing them in a self-storage unit, and they're paying $275 a month. And how does that make sense, right? How does it make sense to have landscaping contracts from 1987 in a storage facility? It really doesn't. So the association should have a destruction, the resolution that I'm talking about, a destruction provision so that the association can destroy things in an orderly way, number one. Number two, in a proper way so that you don't have identity theft issues. So when I say proper, I generally mean shredding, right? Through a reputable shredding corporation that gives you a certificate with respect to shredding, so that if something happens and there is an identity theft case, you say it didn't come from us. We shred everything, right? The truck comes up every 6 months and we put in 3 bankers boxes and that all gets shredded and taken away. And here's my certificate. Um, so that you have to be cautious of that. There's something that comes up, and it's been coming up more recently because everyone has a lawyer in their family these days. Litigation hold letters. So litigation hold letters are when someone feels they've been wronged, and you get a letter. It's often from an attorney, but not always. And it says you have to preserve any and all documents with respect to this issue or that issue or what have you. You need to consult your attorney with respect to that, right? You don't want to destroy things that may be a topic of litigation, because you may wind up with what's called a negative interest, a negative inference uh, from the court, right? So the court may say, because the association destroy this document that would have shed light on this issue, I'm going to direct the jury or the finder of fact to take a negative inference with respect to that and say that the association perhaps did something improper there. So you don't want to give rise to a negative inference. Threats cost everyone money. You want to communicate this all the time. Threats cost everyone money, and they cost everyone money because they jack your insurance premiums. They jack your underwriting issues. They jack often your loss run if there is an actual claim, as do things like, I'm directly calling your insurance agent and I'm submitting a claim. That makes no sense. All it does is drive up your insurance cost and hurt your underwriting profile, right? That's not right. That is not somebody, in my opinion, approaching an issue with the association in a productive way. Okay, not good. Insurgency tactics and wag the dog politics. Information demands as a harassment tool. So if you feel that you're in a situation where you have information demands that may otherwise be justified, but they're being used as a harassment tool, what am I talking about? I hereby demand all audits and all financial statements from 1987 forward. Well, that's not reasonable, right? That's not reasonable. That's not really relevant. I'm not going to sideline my management team for the next 6 months pulling documents for you. How am I going to do that? I'm going to give you what's reasonable. I'm going to comply. I'm going to talk to the lawyers. I'm going to look at DCA policy, and I'm going to give the information that is required and reasonable. And it can't be used as a basis for harassing the board or harassing staff. Now, as I said, the association does have to comply with the laws and regulations, but the association should be in contact with its attorney in terms of reasonable production. What is reasonable? What is not? What is a reasonable time frame? What is not? What is required time frame? What is not? Because it's a very different thing to say, hey, can I have the snow removal contracts for the past 2 years? And you get them to the person within the time frame under the reg, as opposed to, I want the minutes of all association meetings from, date back to 1986. Okay. So there is a reasonableness standard with respect to association board conduct. Another claim where we get into driving attorney fees. So what happens is, so put aside the section about using document demands as harassment tools. A follow-up to that is, and it usually happens with document demands being used as harassment tools, is your attorney fees are just crazy. Why is this board spending so much money on attorney fees? Okay. The reason I highlight that here is oftentimes if you have a person who is, in my opinion, not acting in what I would say is good faith or using discovery or document production as a harassment tool, the attorney for the association has to continually get involved, has to continually make calls. What should be produced, what doesn't have to be produced. I have to come to meetings because there are people yelling all the time, people are interrupting the meeting, people are stopping the meeting, etc. And what that does is the person then comes after 6 months of causing this chaos and then go, oh my gosh, this board is awful. Did you see our attorney fees? That's an insurgency tactic. That's an insurgency tactic where the very person who is causing the chaos is then using the chaos as a means of attacking the sitting administration. So you have to be cautious about that. And if you are being addressed in that way, the board is well within its rights to explain, thank you so much for bringing that up. Let me explain the basis for the attorney fees over the past 6 months, right? The association's board isn't just running around trying to make attorneys wealthy. The association's board is handling repeated attacks and issues that are being driven by none other than, fill in the blank. So you got to be careful about that. Another note that I put in there is beware of uncontested elections. Beware of uncontested election. I know that's a little outside the scope of this, but recently this came up, and it has come up more than once. Hey, Fran, we have an uncontested an election. Not a big deal, is it? It is a big deal. Why? Because under Radburn, there has to be a write-in slot for each vacant seat. And what happens is if you have an uncontested election, say you have two people running for two seats, and then so you have the two people's names on the ballot, and then you have two open slots. If it's uncontested, people will say, "Ah, what's the big deal? It's not going to be a problem." But if a group gets behind a write-in candidate, a write-in candidate can steal the election. A write-in candidate can steal the election, and you wind up being complacent, and you wind up having a board member that might not otherwise have won an election because the community was complacent. This goes also for a situation where you have, say, two seats available and only one candidate nominated and running. You wind up with a write-in candidate who may have only gotten one or two votes, right? So a sitting board should think about cultivating candidates to support the association and run. Another thing that I have here is just say no, and I've talked about this in the past. I think this was Nancy Reagan's issue. Just say no. The board should not, if the consensus of the board on an issue is no, we are not going to do that, the board should vote and say that. The board should vote and say that. The reason I say that is many times, and this is very, very frustrating to managers, is if the board doesn't just say no, I make a motion that we are not going to do whatever. We are not going to put in a new fence. I second it. All in favor? We're not putting in a new fence. Great. if you just don't make that decision and it's tabled month after month after month after month, who are you going to see month after month after month? Or you're going to see the fence guy. I want a new fence. How come it hasn't been decided? Well, we're still looking at it. I want a new fence. We're looking at it. I want a new fence. No, what you want to say is if the consensus of the board is we are not paying for a new fence. We don't need a new fence. We know Bob, the fence guy, wants a new fence, but we made a motion. It was seconded. We had a vote. It was denied. Thank you so much, Bob. Right. But what happens is managers get tortured oftentimes when the board refuses to make a decision and just kicks the can down the road, kicks the can down the road because it continues to create animosity in the community. Just give us a decision, even though it's an annoying decision and even though it's a no. A mulch reminder. I'm going to jump to Mike a little bit in a second. On the mulch reminder, Mike will talk about details on this, but I want to talk about a topic related to mulch before Mike gets into it that I've talked about before, which is the dishwasher case and the association's duty to warn, right? Is it just doesn't apply to mulch, right? So some of you on the call live in high rises or on boards in high rises. So, and Mike will talk about this in further detail, but with respect to a risk and mulch, I think there's a very good argument for, even if you're exempt from the mulch requirement, that the association prepare and file a resolution, have legal prepare and file a resolution that puts people on notice of the risk of having mulch, right, within the 18 inches or what have you. And that also goes for things like what? The high-rise people in Atlantic City and Jersey City, asbestos, asbestos. People go, we don't have asbestos. We don't have asbestos in this community. And many high-rise, especially the older ones, do have asbestos in the units. Where is it found normally? Popcorn ceilings. Popcorn ceilings, not all the time. Everyone remembers we loved popcorn ceilings in the early 80s. Who didn't love popcorn ceilings in the early 80s, especially those ones with little flecks in them, like a disco ball? But oftentimes they had asbestos in them. And if you don't warn people, there's a risk that either a unit owner will sue the association for not warning, number one. Other people will just start ripping the place apart and spread asbestos throughout the common hallways, right, when they remodel. And OSHA coming in and sanctioning the association for having improper working conditions in the community. We've had these claims in common hallways when asbestos drifts out from the remodeling site into the common hallways. Similar arguments with respect to lead-based paint in older high-rise and mid-rise buildings. So these are issues which I think, and Mike's going to talk about the mulch itself, where it's probably wise to have legal counsel prepare a resolution that says, here are some risks that are not the association's responsibility to address, but you're on notice, and so are subsequent purchasers, that these issues may exist in the community, and you, homeowner person, have to deal with them. That also goes with respect to things like water heaters, for example, dryer vents, for example, washer machine hoses. Again, a lot of this is big time in mid-rise and high-rise, because once you have a leak, the water flows down and hurts everybody. That being said, I'm going to flip to Mike, and Mike's going to talk in greater detail about, the pending mulch regulation.
Sure. Thanks, Fran. Hi, everybody. So for those of you who are not aware, in 11 days, that's when the new mulch requirements become effective. So by way of background, this is a update or an amendment to the fire code, the New Jersey Fire Code. It was actually passed a year ago on April 15th, 2024, to become effective 1 year later. The reason why we're all talking about it now and not a year ago as much is we weren't quite sure as to whether or not there'd be any changes to it. And quite frankly, it's pretty expensive to comply with this new mulch regulation. So essentially what it states is that the New Jersey Fire Code applies to all buildings and structures unless you're specifically excluded. And the exclusions are owner-occupied, 1 and 2 family, or attached single-family structures and dwellings. Okay, so who does this pertain to then? All condo associations. Townhomes are technically excluded, but like Fran said, there is a certain risk there that I'll touch on in a moment. and single-family homes are excluded, but the rest of the structures in your single-family home community, it will apply for. That's your clubhouse, and any other building or designated smoking area that you have. So the fire code language, we touched on this last month, but I'll bring it up again. The fire code language states that the use of combustible landscaping materials such as wood-based mulch products is prohibited within 18 inches of any building or structure, within 18 inches of any deck, porch, balcony, or other portion of the building that's made of combustible material, and then within 18 inches of a designated smoking area. The exceptions to that 18-inch rule are that it does not apply if your building is non-combustible from the grade level up to 3 feet. So it doesn't apply there. It doesn't apply if you have what they call fire-resistant mulch, but quite frankly, I don't know what that means. But if you happen to have fire-resistant mulch, I guess made out of stone or something, I don't know, it wouldn't apply. And then finally, live plant materials such as shrubs, flowers, and trees, provided they are not beneath a combustible overhang with less than 6 feet of clearance. So what does this mean? We'll start with condo associations. If you have a typical condo building, that means the mulch needs to be pulled away 18 inches from the building, unless the building itself is not combustible. If it's built with, perhaps stacked stone, or if you have brick or concrete, or actually hardy plank siding, which is like I guess it's a cement-based siding material. The DCA has confirmed that that's going to be exempt. Then you have to pull the mulch away. Also note that even if your building is constructed with non-combustible material, there are areas where you still need to perhaps pull the mulch away. So if you have a deck made with wood, if you have, let's say, columns walking into the entranceway and the columns come down to the ground and they're made of wood or some kind of combustible material, mulch needs to be pulled away from that. If you have PVC piping going through the foundation of the building, or maybe some conduit going through the foundation of the building, mulch needs to be pulled away from that. So essentially, if you have anything that is combustible within 3 feet of the grade on a condo building, mulch needs to be pulled away. Can you leave it just a void right there? I mean, I guess temporarily, but what happens the first time it's going to rain, right? Everything's going to get pushed back in. When it gets windy, it's going to get pushed back in. So you're going to have to fill it with something. Not to mention the fact that if you just leave dirt there, you're probably going to have a weed issue in about, a week or 2 or 3. So to avoid that situation, you're going to want to put something there. So what can we put there? River rock, stone, crushed stone, sand even, whatever else is not combustible, but that's pretty much stone or sand. All right. Go to the other side of the spectrum. You have single-family homes. Owner-occupied single-family homes are exempt. Okay. The clubhouses and other buildings and structures, it will still apply to. So we'll still have to deal with pulling the mulch away from the clubhouse. Again, unless it's all concrete or stacked stone or some other non-combustible material, brick or something. So what does that mean for management if you have a single-family home community? Well, again, the exclusion is for owner-occupied homes. I think it'd be best to perhaps send a notice out to everybody saying, hey, listen, if you're living there, that's fine. It may still be a smart idea, like Fran mentioned. We're in a pretty good position here to just let everybody know what the fire code says. Certainly, if somebody's going to rent out their home, it would be something for the owners to deal with then. All right, pull the mulch away. And then finally, you have townhomes. So the technical language of the fire code provisions state that townhomes are excluded. We touched base with the DCA to get some clarification on this. They confirmed, yes, they are excluded, but there's a very big but there. And the but being, again, it's owner-occupied residences that are excluded. So what happens if you have a rented unit in the middle of a townhome row, right? I would suggest under most circumstances that as the property manager or as a board member, we want to put the owners on notice that where they own their units, and townhomes you own from the 4 corners of the lot and everything on that property, if the owners are responsible for all of the landscaping close to the buildings, we want to at least put them on notice that you need to pull it away. I do think it would be a really smart idea for the association to take on the burden of ensuring that it's done and perhaps even paying for it, just to make sure that you've pulled this away. And the enforcement aspect of this is where this gets a little weird. So you've got two different things to think about. Enforcement is done locally. So that's your local fire code official or your code enforcement official. That's who would be enforcing this. But the real issue that I see, and that we've talked about in the office quite a bit, is the threat of litigation. Let's say the worst case scenario, there is a mulch fire. And if you've ever seen one, what happens is the mulch underneath kind of catches fire. It extends along the building, and eventually the flames burst out and works its way up behind the siding. We've dealt with, I believe, two of those that I'm familiar with, with the communities we work with over the years, and they can be significant. So if you have the worst case scenario where there is a mulch fire, and perhaps it's even the worst case and somebody passes away or you have an injury, more likely than not, there's going to be a lawsuit. And if the association in any way had any responsibility for dealing with that mulch, if the association didn't put them on notice, if a unit was rented, et cetera, et cetera, et cetera, and there was no exclusion, I think there's a really good chance that the association would get jammed up in this lawsuit and would ultimately become liable for a certain percentage of the damages. And that's a scary proposition. I'm sure personal injury lawyers would like to make the argument that, especially with a condo, if a association chose to disregard the fire code and just never pulled the mulch back, they would make the argument of negligence per se. Here's the standard. You deviated from the standard. You knowingly did this, board members, and we're going to come after you personally. That's a scary proposition that no board member wants to deal with, I'm sure. When you volunteer on a board, you don't want to put your personal assets on the line. Long story short, I would say let's be pretty cautious with this. It's a fire code issue. It's a life safety issue. If we're really unsure about it, I would say let's pull the mulch away from the buildings and make sure we're doing our best to take action to prevent fires. Usually, before I look at the questions, one of the first questions is what happens if the owners are responsible for like the 3 feet out from the building? Where you have a condo association, it's still common property. In almost every circumstance, I mean, there may be an exception here or there, but in almost every circumstance, it's still owned by the association. So association needs to make sure that mulch is properly pulled back, all right? With townhomes, the owners own that area typically, but the association perhaps may be responsible for the landscaping in front of the units, in which case we would have a responsibility to pull that back, or at least put the owners on notice that if it's going to be rented, they would need to pull it back, or if it's not owner occupied. So again, the 15th is, what is that, a week and a half, something like that? Yeah, a week and a half is the effective date for this. Local municipalities enforce. And just in case any of your boards ask, hey, why are we dealing with this now? This has been out there for a year, almost a year. Why now? My answer is to the boards and management companies, you never know what would have changed. This is not a law passed by the legislature. This is under the executive branch. This is a regulation under the guise of the DCA, Department of Community Affairs. And sometimes there's changes. And had a change happened after an association spent 6 figures removing mulch and putting down stone, I don't think you'd have happy board members and happy residents. So now would be the time that we start looking into this and taking some action to address it. So turn it back over to you, Fran.
Yeah, thanks, Mike. Just wanted to drop another footnote. We haven't gotten into this. I haven't done a whole lot of research on it, but Jim Zarzecki from ACV Property Management had also sent over a notice from, for those of you who know where Pennsauken is in South Jersey, from the Township of Pennsauken Fire Department that kind of gave a little brief overview of some of the mulch issues. But one thing that Jim highlighted was the fire department there was also highlighting the fact that there's a provision in these regs that says fire escape stairways and balconies shall be examined for structural adequacy and safety by a registered design professional every 5 years. An inspection report shall be submitted to the fire code official after such examination. So many of the people on this call may not have fire escapes, right? But and this I think applies, again, don't quote me on this. I think this applies to triplexes and above, triplexes and above. But the issue there is, even though you don't have like old school fire escapes on your buildings like Brooklyn, right, or South Philly or somewhere, those types of fire escapes, there is still exterior egress, which is exterior fire egress. So if you have cluster condo units, et cetera, speak to your engineering firm and find out if that requirement applies to your building types. So we represent a number of associations that have those old school um, exposed to the open stairwells that go and give access to stacked units up 3 or 4 stories. Even though they don't look like the Brooklyn old school fire escapes, they do serve as exterior egress stairs, and they may very well come under this requirement to be tested every 5 years. So if you're in that type, if you have any questions regarding that, please speak to your engineering professional and find out if your buildings fall under that reg, and if so, what the township will require in terms of a report. And your engineering company is going to have to get that to the township every 5 years. That being said, let's jump into some questions. Mike, you want to take the first one?
Sure. Jim writes, I think it's also good to share the bad news and how the board is addressing it so it has perspective. I think we're just talking about putting bad news out there to the membership up front before it makes its way from the membership to the board. And I think that is also a good idea.
Most definitely. So that's a great point, Jim. And that is especially important in today's world with the structural inspection laws and the reserve funding laws, right? So there are still many, many, many associations who have not come up to compliance with reserve funding, structural inspection, things like that. Please do not hide that, because what we're going to run into is, hi, Mr. McGovern, I bought in on April 1st, and shockingly, there's a special assessment for $30,000 per unit because the decks are falling off. I had no idea of that, and I thought it would all be addressed by reserve funds, but um, it wasn't. How is that possible? Because the reserve fund law says it should be properly funded. So Jim makes a good point. We should share the good and the bad. And if you are sharing the good and the bad, make sure, if you're sharing the bad, which you should, uh, and I think Jim's right about that, what are you doing about it? What's your plan? What's going on? What steps are you taking? When are you going to have the special meeting to talk about the shortfall, et cetera, et cetera? Where do we find document retention guidelines, resolution samples, et cetera? So that would be McGovern Legal Services, and we would happily have you sign a retainer letter, Anna, and we could talk about it. So that, so most people are formulating document retention policies with their lawyers, their law firm, and it depends on the association, what the association has, and it all, things like IRS regulations often play into that as well. So speak to your counsel on that, Anna. Go ahead, Mike.
Sure. One of the issues of a 55 and older community is a computer literacy, and a portal doesn't do much good. We're trying with email blast. Yeah, I mean, whether it's posting notices in the clubhouse, whether it's sending out actual hard copy, newsletters, whether it's mailings, posting things on the association's website. And I understand sometimes working your way through a portal can be challenging. So there's different ways to get the information out there, and to the extent possible, do what you can is what I would suggest.
Right, and some other tools are phone blasts. If you have that app that has a phone blast that goes out to everyone, you can formulate with management a phone blast. And I hate to say this, but you get the good and the bad, as Jim said. Hi, everyone. We want to let you know that even though this wasn't a huge snow year, people don't be deceived, because there were a lot of icing events, and we went over our snow removal budget by $70,000, not because there was a bunch of snow out there, but because we had a number of icing events, and we will be adjusting the budget, or blah, blah, blah. So people who may not be into computers or going on to web portals may get that and may at least show up at the next open meeting to talk about the budget and to understand that, there's a reason the budget is going to be adjusted because of ice events, things like that. Can board members vote online before voting at open meetings? So, yeah, Colleen, so this comes up a lot. The answer is board members can vote all the time at all different kinds of things. The thing is, though, those votes are, until they're at an open meeting, they're just straw poll votes. You see what I'm saying? So if you have members in an executive session that is they're considering an open meeting topic, and the board president says, "Hey, I just want to get someone consensus on this. What do you think about the landscaper?" Blah 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 blah. It goes around the room, and they all say, "We're going to hire XYZ landscaper." That vote may come down in favor of XYZ. That vote means nothing, and the association shouldn't be signing contracts based on that vote. The vote is not binding. There shouldn't be a binding vote until the open meeting vote. So you could take straw poll votes, but it's not binding until it's at an open meeting. With the exception to that, as you know, is executive session votes where it's on attorney-client privilege, litigation strategy, personnel matters, or contract negotiations. Go ahead, Mike.
Are board members generally allowed to discuss board issues with homeowners? That's part one of the question from Paul. I mean, if you're discussing something in executive session, generally speaking, I would suggest that stays in executive session. A lot of times, whether it's negotiating contracts, talking about an employee issue, whatever the issue is that you're in depth talking about, those conversations typically should stay behind closed doors. How long are boards typically required to maintain records like dates of roof replacements, and can they burn everything? So, good question. When we put together something like a document retention resolution, we kind of go through and break down a whole bunch of different items, from financial items that should last at least 7 years to a lot of board meeting minutes, to, we'll say, voting. The ballots need to be maintained for 90 days. You have an obligation to maintain your, let's see, board meeting notices and your annual meeting notices for 2 years. But something like roof replacements, you're going to want to maintain that for a long time, right? You're going to want to know when the roofs were replaced.
Right.
So
Yeah.
I think the answer is there's no set answer for all documents. It just depends on the type of document.
Yep. I think I might have skipped Anthony up there. Some residents have asked for bid documents before the bid has been awarded. We've responded that since the bid has not been awarded, we cannot disclose. That's true, Anthony. So, but after the fact, they can look at bid documents once the contract has been awarded. I just wanted to also highlight one other thing that to build on what Mike said about executive session meeting and topics. Our board members generally allowed to discuss board issues with homeowners. So as Mike said, if it's an executive session only topic, right? Attorney-client privilege, litigation privilege, personnel, contract negotiation, the answer would be no. However, oftentimes residents take that answer from me or Mike or whoever the attorney may be, and they say, well, the board can't talk about anything discussed during executive session. If the board talks about something in executive session that is not one of the confidential topics in executive session, the board member is free to talk about it outside of executive session. So if I'm a board member and I'm sitting in executive session and we go, let's negotiate this contract, blah, blah, blah. Let's discipline this employee, blah, blah, blah. None of that I can talk about outside of executive session. But if during the same meeting I say, you know what, we're thinking about painting the shutters and I tend towards, forest green, and Mary Jane chimes in and she goes, well, I really like robin egg blue. And then I leave that executive session and Mary Jane goes and talks to her friends and says, that guy Fran McGovern really likes forest green, and that's crazy. Nobody in this world would put them forest green, and I like robin egg blue. I can't go, haha, Mary Jane, you violated your fiduciary duty of confidentiality, because no, that discussion is not confidential information. You see what I'm saying? So executive discussion, okay, it protects confidential information. But if other topics are discussed, then you can't do a gotcha on a board member if it wasn't a confidential topic. Does that make sense? Okay, because a lot of times, especially on split boards, the board members are trying to constantly get each other on gotcha moments. And a lot of times they'll say stuff that they discussed outside of executive session, but it's not confidential at all. So they call us and we go, no, it's okay if they talked about the color of the shutters. Okay, so that's that. Um, Do your boards have open meetings in a common area and only in closed meeting when discussing personnel issues, specific owner issues, and contract negotiations? So open meetings, right? It doesn't, so there, you can have open meetings on Zoom, like right now, right? So people can come and have them on Zoom. It doesn't have to be in a common area. We prefer them to be in common area. One thing, so there are many associations who do not have common areas where you could meet, right? So there are many associations don't have clubhouses, don't have common areas where they can meet. And back in the old days, and still sometime in the new days, is the board will meet in a residence unit or a residence home. We are very much against that, right? That's not a good idea for several reasons. Number one, if there's a problem, you're in a home of a homeowner. That's number one. Uh, Number two, some people are intimidated from going to an open board meeting if it happens to be in the board member's home. So we don't like that. So people goes, well, what do we do, Fran? We don't have any options. Of course you have options. There are libraries, synagogues, churches, right? Municipal buildings, VFW halls. So you can still have them in a forum that is appropriate for having an open meeting, and you don't have to have them in the member's home. And people will say, well, Fran, that's crazy. It's going to cost us $150 or whatever to rent the fire hall. That's a business expense. Spend $150. Okay. Does that make some sense?
Mhm.
So, have open meetings in open places. The kind of brief reference to executive sessions, right? It's attorney-client privilege, litigation privilege, contract negotiation, personnel issues, and inherently private matters. So usually that's collections and disability discussions, right? Go ahead, Mike.
All right, so yeah, Colleen made a point here. So I think this was when I was talking about the non-combustible mulch. What does that mean? And Colleen wrote made out of rubber. So by the way, Colleen, I also originally thought that that was not combustible. Turns out it is. Turns out if that catches on fire, that burns really badly and burns a lot. So it is combustible, and therefore we cannot just pull mulch and put down rubber mulch. And then I'll take the next one real quick.
Go ahead.
Alan writes, does the grade level up to 3 feet apply if there's a brick front higher than that level? So if you have a building, a condo building, a clubhouse, whatever kind of building that the fire code applies to, it says the first 3 feet are what we are looking at. And if you have a brick facade, let's say, that is non-combustible over 3 feet, maybe 5 feet or so, then that building would be exempt to the extent that you only have the brick there. So if you have something like PVC piping extending from the first 5 feet, if you have pilings, if you have, I don't know, a deck, something like that that is combustible, the answer is mulch needs to be pulled away from that particular area.
Go ahead, Mike. You might as well take Morris's too,
Sure.
because he has
Actually,
one more.
Jeff wrote me a message here, Jeff Schiffman.
Okay.
It was reported today that a townhome with at least one owner-occupied townhome unit qualifies the building to be exempt. Jeff, that very well may be the case. I understand the DCA is suggesting that's the case. So we're talking about whether or not if you have a townhome and there's 5 units, let's say, and one of those is, rented and the rest are owner occupied, or vice versa. If you have a mix, how about the building itself? Is that, does that qualify? And are they required to pull the mulch back? I think at the end of the day, you will end up litigating that issue, and it's going to be determined by a judge whether or not the entire building is exempt or not. I'm just looking at the plain language of of the code, in which it states that the exclusion only applies to owner-occupied, attached, and detached dwellings. So
Okay.
yeah, that may ultimately be the answer, Jeff, but at the end of the day, I think you'd have to fight over it to get to that point, and it might make a lot more sense to pull the mulch back first and avoid the lawsuit.
Mike, you want to talk to we already said it, but the freestanding clubhouse?
Yep, freestanding clubhouses, absolutely, that falls within the purview of the fire code. Mulch needs to be pulled back from the clubhouses, correct?
Right. And,
Um,
Lori jumps in and says, what if, hi, Lori, by the way, what if the single family homes and townhomes are condominium ownership? So then it's going to apply. You got to pull
Yeah,
it.
100% applies. Yeah, they actually look at the zoning codes, the R2, which is condo. So even though it looks like a townhome or looks like single family homes or attached duplexes, Sometimes they are actually set up as condos, and therefore the fire code does apply to it.
So Kathy says, do you have model language for alerting people to this issue? We do not yet, Kathy. So we don't, but we'd be happy to provide it.
Yeah, I have something
This is
I
going
can
to
send
say,
over.
this is going to sound awful for a fee.
Fair enough. Al wrote me a message. So a duplex HOA is exempt. Yes, Al, a HOA is exempt, but something like your community, they're actually set up as condominium associate. It's a condo, even though there's duplexes, and therefore it does apply.
Okay.
Fred, you want to take the next one?
Which one are we on here? What happened?
I'll read the question. Some residents have asked for bid documents before the bid has been awarded.
Oh, I already
Really,
talked about that one. Yeah, I
okay.
did that one. Yeah, they don't get them.
Right. Vicky asks, if you have plantings within 18 inches, then you are excluded. When you remove the mulch, can you leave just dirt? So the plantings originally were going to need to be removed from the 18 inches. That was the first draft of the amended fire code that subsequently changed when it was published. So plantings that are live are okay within 18 inches. The mulch needs to be pulled back though. Can you just leave dirt? Yes, but it's not really going to last. Again, once you have rain or something, it's going to come back. So I think perhaps to comply by the 15th, you pull it back and then start getting quotes from landscapers would be my suggestion, to put down some rock or stone or something.
Nick says, what happens if the association pulled the mulch away and then the homeowner puts the mulch or some type of other combustible item back in the 18 inches strip? It really depends. And Mike, you can chime in on this too. It really depends on whether you're obligated, right? You're obligated to do that. It's a condo association or some other non-exempt type structure, or it's not. So it really depends. You have to speak to your own attorney about that, depending on whether it's a condo, what association responsibility goes into maintaining, repairing, replacing those planting beds, et cetera. Right. So it's very fact sensitive at that point.
Oh, I'm sorry, friend.
Go ahead.
Alex writes, individual single-family units where the master deed says that the property outside the footprint is the house of the house is common property. Would that make the responsibility for removing the mulch an association responsibility, not the individual unit owner? Yes. At the end of the day, if you have a master deed, it is a condo association. Therefore, the association ends up holding the bag on this. So we would need to make sure it's done. The association should deal with it.
Yep. So Bill Farrager says the DCA is now requesting a certificate for load bearing test. That goes to the fire escapes bill. So that's right. And that's an every 5-year thing.
Connie Ann writes, I brought up balcony inspections to management months ago. Always wondered who was responsible for inspecting and maintaining them. Yes, I mentioned to management we should tell residents they are liable for the maintenance of the balconies.
Go. Well, I'll tell you my take on that real quick. It depends. It depends on who owns what, who's responsible for maintenance, repair, and replacement of balconies, because that varies very much between, say, fee simple townhomes to condominium associations to co-ops to fee simple townhomes, but the association is tasked with maintaining, repair, and replacing the exterior. So that really is fact sensitive and depends on your documents.
Vicky writes, doesn't the mulch law seem to be discriminating against tenants? I mean, honestly, if you think about it, for some reason, I'm not quite sure why single family homes are excluded from the fire code in New Jersey. Seems odd to me, but yeah, I mean, I hear what you're saying, Vicky, but such is life in New Jersey, right?
Right. So, and that's why we said earlier, even if you're a single family home community, like many of you are, I recognize many of you, it's still good, in my opinion, to record the resolution because of the possible duty to warn liability, right? And it's not like the association in a single family home community would go in and start removing mulch and doing things like that. But at least it puts people on notice not to do it so that you don't have a case where a fire happens and the association winds up getting sued, not for not removing the mulch, but for not warning people of it. So you just got to be careful. It's a risk management thing. Colleen says, thanks. Hi, Colleen. Go ahead, Mike.
Here, you can take this. Says, do you have any suggestions on how to supplement the reserve fund? They had a president steal $1 million from us years ago. We're having a tough time catching back up.
Oh, Terry. Oh, that's awful. So yeah, I can't put the cow back in the barn, unfortunately, if someone stole $1 million from you. That's why, by the way, just as a footnote from Terry's point is you should all have theft insurance. You'd also have bonding requirements. In the large case, the large theft case that we dealt with a year and a half ago, we recovered $450,000 from the association's insurance policy, right? So one thing going forward, Terry, I can say, I know this is cold consolation, is make sure the association is properly insured, that there are proper financial controls in dealing with the money going forward, because unfortunately we have seen associations being taken advantage of more than once. And that's not a good thing. Um, but in terms of supplementing the reserve fund, very difficult, very difficult. The answer to that is deal with it sooner rather than later, because you number one, the law does not require you and does not allow you to kick the can down the road any further. You got to get on it. And number two, not doing it is going to expose you to possible liability, expose you to, not meaning you, but the association, to not meeting mortgage lenders' requirements for compliance with law, and not meeting insurers' requirements in terms of compliance with law. So it's going to hurt your association greatly if you don't deal with that now. Go ahead, Mike.
Yep. Next question. If the board holds open board meetings via Zoom, are they required to make reasonable accommodations for shareholders who do not have access to a computer or are not technologically proficient? So the reasonable accommodation issue comes up where somebody has a disability and then asks the association for for an accommodation to address their particular disability. Generally speaking, I would imagine that having it on Zoom would actually alleviate or accommodate most disabilities. But so I guess that issue's not come up with me. We'd have to take a look at it if it did, but
Yeah. So I'll throw in my 2 cents here. So we have had in certain associations, I think some of the residents from this community are online with us right now. We have had communities with hearing impaired residents, right? And we have hired signers. Uh, so the one thing with Zoom that you have to be cautious of, and this is referring to Mike's comments on disability, but I think the question might be more aimed at just people who are not up to snuff on the computer world these days, right? So one thing you can do with this, and we actually did this in a community in Ocean County, where the board members refused to use email. You may have heard me say this before. No, you can't do that. You can't refuse to use email. That's like in 1972, a board member refusing to use the telephone, because they grew up and we never had a phone in our house, right? We never had a phone in our house. We had to use a party line down the road, whatever. We had to go to the corner store and use the phone. No. So it's a regular business tool. So what we did there, and I think you could do this in your association to address this, we don't use computer things. We set up a common computer setup in the clubhouse, where people could come in this case, the board members, but in other cases where members, if they were unable to use a computer, they could sit at a computer set up, a big screen even on the wall in the clubhouse to watch the meeting by Zoom. The reason I say that is, especially with snowbird communities, Zoom meetings may not be held live because people are in Arizona or Phoenix or Miami Beach or what have you. And it's not like the people are going to fly in from Miami Beach to attend an in-person board meeting. So I would say it's a good idea to make the meetings open and accessible, even putting disability aside. And you can do it by setting up a screen in a common room to do that. Go ahead, Mike.
should all board members agree when voting in open board meetings? My personal opinion is no.
No.
No, you should show your dissent and why you disagree with the majority, make the record, so that the members understand that everybody has their own opinion on something and you have to vote and proceed as a whole, as a majority on the board. Fran, you want to take this? Would you repeat the
Paul,
list of, oh, I'm sorry.
Paul says, thanks, Fran. Now I know why they didn't pick you. Do you represent individuals against homeowners association? So, well, thanks. I'm going to take that as a compliment, Paul. But no, we only represent associations. We don't represent individuals against homeowner associations. We don't represent developers. We don't represent members. No. But thanks. I'll take that as a compliment, Paul.
Ed asked, would you repeat the list of confidential topics not to be discussed outside of executive sessions? So it's pending or anticipated litigation, employer-employee issues, negotiating contracts, and finally, the fourth one is inherently private issues such as collections or reasonable accommodation requests.
Yep. So Denise says, our fire marshal Putin, I don't know if that was a joke, but writing that although we are a condo association, since our buildings are townhouse design, we are R5 and exempt. So people are, as this plays out, people are going to have all types of opinions and interpretations, including your local fire official. Our advice would be, as the lawyers and risk management opinions, and again, this is not legal advice, right? You heard my disclaimer earlier. We would, if you're responsible as the condo association, pull it back anyway. So I know that may not be a popular advice and people may disregard that. You have a compliance issue, and I think the most conservative compliance would be to pull it back. And from a risk management standpoint, pulling it back would make sense too.
And a quick note on that, I did ask the DCA, who has some authority to interpret this, that particular question. Their position was that if it is a condo association and that's what you obtained your certificate of occupancies for, and it would stay down there, it's actually an R2 for condos and therefore does apply. So, who knows? I think if it's not pulled back and there's a fire, you're going to end up litigating that issue, would be my suspicion.
Right. Ken says, can the board prohibit shareholders from asking questions at an open meeting or restrict shareholders to asking only one question? So yes and no, right? So yes and no. The chair chairs the meeting and runs the meeting. Again, this is my opinion in favor of transparency. The association should entertain questions from all of the members. What I think a good practice is to limit the questions to one question. Stay with me. Stay with me. I see people freaking already. Limit the questions to one question, and then you go to the back of the line. You see what I'm saying? So we have many communities, especially in adult communities, where there's the mic up there for questions to the board, and Bob steps up to the mic and says, I have 35 questions for the board, and most of these questions are not questions. They're actually accusations of me screaming. What was the title of today's seminar? The board members are lying, stealing scumbags, right? And Bob stands up there for 10 minutes explaining why the board members are lying, stealing scumbags. So no, what we see in those types of situations are Bob comes up and says, can you tell me when the budget will be approved? It will be approved at next month's meeting. Yes, and now I have a question on why you're not funding reserves. Okay, Bob, thank you so much. Go to the back of the line and we will entertain that question, right? It shouldn't be a situation where one person gets up and just launches into speeches that last half the night. The other thing is the chair is running the meeting, and this is, I think, a burden on board members, and some board members believe that they must stay at the meeting until every question in the community is exhausted, right? So even if you have a situation where it's one question, the line will keep going all night, and Mary Jane or Bob or whoever it is will keep alternating each other until it's 11:15 at night. No board is obligated to sit there and entertain questions until 11:15 at night. The board has every right to say, we've entertained questions for X number of amount of time, and it is now 8:30 or 9 o'clock at night. I make a motion to adjourn, but I have more questions. I have more accusations. I have more things that I'm going to call you a liar about, and you must stay here because I own you. No. Those people are not running the board. They don't own the board. They don't own you as the board president. And the board president has the ability to end the meeting after a reasonable amount of time. They don't have to stay there till 11 o'clock at night. So should those questions be entertained later? Yes. I think there was a politician recently who did a speech for 24 hours in front of a microphone somewhere. I don't know. I got a blast email on it. I don't know who it was, but okay. So whoever it was, no, you don't have an obligation to sit there all night while someone does a filibuster or a 24-hour speech. Go ahead, Mike.
All right, Anna sent over the fire info or mulch fire info from the state of New Jersey. We'll have to take a look at that. Thanks for sending that over. Alan writes, did I hear that live plant or shrub material within 18 inches is exempt? Alan, that's correct. Again, that was not in the original proposed language. It was subsequently amended and then published as exempting live plant material, yes.
Okay. Phyllis says our association holds 4 open meetings a year. Uh, that's fine, Phyllis, as long as they're only making their regular decisions 4 times a year, the binding decisions. And that's fine if that's what they do. They might not have that much business. But if you're going to be making decisions that are binding, they should be made at an open meeting. So a board member can't say, well, we're not making a decision in an open meeting because it's only February of the year and we don't have our meeting until whatever it is, April 1st. No, the binding decisions have to be made at open meetings. Um,
Here's a question. How often will the follow-up checking of mulch occur? Lori, nobody knows. So again, that's local enforcement on enforcing the mulch removal. I think the real concern, though, is the liability that we talked about. That God forbid there is a fire and we did not pull it back. There's going to be significant liability on the board and the association.
okay. Phyllis says all other meetings are closed to the owners. Is this appropriate? It's appropriate to have closed meetings, which would wind up being workshop sessions, Phyllis, if no binding votes are being made at those meetings. If there are binding votes being made at those meetings that are outside the exempt topics, they should be made in an open session. Go ahead, Mike.
They're telling us, Connie Ann writes, they are telling us to raise our fees, but we are so low in reserves. If we charged residents $1,000 a month, we wouldn't be able to catch up in time. How could we throw it on the back of the residents? So this is a reserve funding question, and the statute requires compliance with the reserve study on the annual funding contributions, not the underlying balance sitting in your account. So I understand what you're saying, that sometimes it is excruciatingly difficult. We've had some communities triple, that's the highest I've seen, triple their monthly fee to get caught up with reserves. But I understand the frustration, but compliance, I think, is required on this. So.
What you're going to see, and people hate to hear this, is associations are a moving train, right? The train just keeps moving, and in the lifetime of the corporation, the association, right? So as this, we'll call it financial squeeze, with requirements for reserve funding, becomes more and more public, and more realtors see these issues come up at closing, because I think realtors are obligated to disclose something like this, right? They're supposed to be aware of it and disclose it. You're going to see sales price adjustments. So, for example, if you see, Connie, a unit in your community and an identical unit across the street in a different community that is properly funded, in theory, the homes in your community should sell for that much less. Does that make sense from a financial standpoint? People are going to, if they're savvy and they're fully informed by their realtors, pay less for a community that's not properly funded. Go ahead, Mike.
Hired signers in the past from Colleen. Understood. Lori, all these rules made by the state, thinking in the extreme what happens if a condo association goes bankrupt. I've been doing this for 18 years. I've never seen an association qualify for bankruptcy. Fran, you may have dealt with it prior to my involvement. I don't know.
Yeah. I've seen multiple associations go into either receivership or a similar procedure under state law rather than go into federal bankruptcy. That crushes an association from a resale standpoint. So where things might get really crazy, Lori, is what if the economy, God forbid, tanked like it did in 28, right? So 2008, imagine the economy tanks and we are stretched by this law, and people are saying the law still applies, the law still applies, the law still applies. People will just be unable to pay it. So something will have to give, right? So that's going to be the really interesting question, is if the economy were to tank, how would that impact on reserve funding laws?
Another question here is going back to Terry's question, can a former board president be personally sued by the association or the owners on a personal basis? Certainly, anybody could sue anybody for any reason, right?
Yeah.
Where you have somebody suing a condo association board president, if they're suing for something that was covered under their tenure on the board and something that's covered under their fiduciary obligations, most likely the association's D&O policy is going to provide coverage. And ultimately, the association's premiums end up going up, not to mention the fact that the association probably has indemnification language in their governing docs. If they did something outside the scope of that, then yes, they can be held personally responsible, such as, stealing money or something like that.
Yeah. Connie Ann says he was sued. I guess this is the person who stole, and we collected some dollars, but that fell into the hands of board members who weren't doing the right thing with the money. We need help. We need help, and we can't suck it out of the residents who have lived through this in the entire community. So this is the problem with government generally, and this is not a political statement at all, but when people say we need help because the money was dissipated or not properly reserved for, not set aside or whatever, where would that money come from? Right? It's very easy to say, we would really like to take Madeline's money or Mark Sirks's money or Joseph's money, right? But if you don't have the money, uh, regardless of how kind the other people are, it's going to be unlikely that they're going to be very enthusiastic about parting with their money to fulfill the hole that has been created in your community's financial situation. So that's the one thing. You have to work with your lawyers, your accountants, your auditors, et cetera, planners, to try and structure it so that you can get help. Because in terms of help them help you, because I don't see the money coming from elsewhere at this point. Go ahead,
Fran,
Mike.
what differences do you see in transparency and similar policies for smaller HOAs like 24 units? How do they generally differ from large ones, and what are the common problems you see when they're small?
So the smallest communities really, we're gonna have to cut it off pretty soon because Joseph's gonna have to log off. So we want to respect the time limits if we can here. So the biggest problem with small communities is number one, at the outset of the community, a desire to sue a developer that has created construction defects. They almost can never afford to litigate, even though they may have severe construction defects. That's the biggest issue. And many small associations cannot afford to hire engineers, legal, and financial people that larger associations can spread the unit cost over. My advice to those people would be rely heavily on professional management, right? Make sure you get a good management company, because if you get a good management company and pay them a fair fee, they can usually help you avoid these issues of um, lack of transparency, of having to resort to attorneys and fighting with people, of having unnecessary insurance claims. So if I was involved in a small association, my number one concern always is getting good management, paying an appropriate fee for good management, because that often short circuits other problems. Go ahead, Mike.
All right. Joseph writes, what about concrete foundation and siding? I guess we're talking about the mulch. If the concrete foundation is more than 3 feet high, the exemption would apply, except for, like I said before, things that are not that are combustible. PVC piping, conduit, decks, columns holding up, something. So it just depends on the building and whatever else you have under that 3 feet area.
Yep. We're going to blast through this now. Ken says, how detailed do board meeting agendas have to be, especially regarding contract approvals? Not much, Ken. Consideration of landscaping agreement. That's enough. How can we conduct a binding vote with an RFP when not all the contract terms are included? So Carlos, I think we may have talked about this in the past. The the board approves the vendor, right? Under a fiduciary duty, the board is not typically, and they can if they want, but I rarely see board members parsing the commas, the semicolons, of the contract language itself. So board members do not have to go line through line through the contract itself. So that's the answer there. The fiduciary duty can be fulfilled by reliance on professionals or the board member's own experience. So as you know, Carlos, and I believe you do as well, have vast experience in contract issues. You don't have to be a lawyer to be really, really knowledgeable about contract issues. And you can vote based on that, or you can vote based on your engineering's input or your legal input or your financial input. So I think that's it for the day. That's it for the day. It's 5:25. That was like a marathon for us. And we made it in time that Joseph is still with us. High five to Joseph today. I hope you're having a great night. And it's great to see everyone. And we thank you as usual. We love you attending these seminars and we really appreciate it. Have a great weekend.